Thank you.
Kita selalu sini buat musik apa nama mereka selalu banyak ada hati yang ada kalau sesuatu itu kalau ini bahasa lu sebenarnya kamu menurut kita apa fase tahu alu pun dekat di hati sesuatu kalau ini nanti kita hai dia hati bahasa lu sebenarnya kalau sesuatu yang sesuatu sama bak di lupa buat sama dengan kota infantil itu ini masalah sesuatu ya kami lawan ini yang kasih halu infantil sesuatu kita kota dekat halu dan kita kait sana khususnya apa kalau kita ini baru nah khususnya bakal kita dia sama hati kita bisa masih bisa mengatur anda berkhusyuk dapat susah bersama dengan bapak atau mereka berkhusyuk sebagai kisah anda berkhusyuk dapat silakan dilawan bersama anda berkhusyuk kayak siapa pesan dari khusyuk masih ada apa kalau itu nanti kasih sekali ya dua kali satu kamu pagi ini kerja di sini kemudian itu kerja sehari kayak saya nak kalau suatu sekali kabarnya orang bantu kasus secara baik dalam siwa satu ini melawan ini hampir pasti harus mesti cari file kali ini ini hampir apa sebab ini ini dari kita dari salah kalau satu video video seperti itu sampai khusyuk bagi sekolah misalkan kalau satu kan sudah kita khusyuk wanita anak cewek kawa orang tinggi anak cewek harus ada sisi aku rasa yang ada bagaimana ada kabarnya kan bukan loya berasa satu ya bagaimana dia mana dia punya dia ila itu yang kamu pakai musik atau iwe khusyuk wanita yang lawan anak atau itu yang sahas itu hati laksana itu ini kita tahu bahwa patah aku nak mana sila ya awal dia dia hati wasa pada masa itu babanya dia awal dia hati kunci itu belajar kasih kita mana baca nak dia akan kalau wana itu sebenarnya ditama kamu khusyuk bahasa ini wana abona sama bakal sesuatu kaya sana ko ini memang khusyuk apa apa sudah bila salusa khoruna dapat khusyuk awalnya itu pemain tetapi ini naniona ya sama sih ya hampir sisi sama lagi dia sudah situnya la sisa corresponde sabana abanyani ya kuwashamisa no kesalo ngena inalizithunya tsempini iphatana manibali ulufumana isithunya sesingosi sesisabudeli abathina osika sesihlalo sakho khusyuk abanithani ukhusyuk ababili bafikela isi kutamabonisa bupati babatawusibikisana kubasibikisana lakuba khusyuk le hape wa hlalosa gore e nngwe ya ditlhapo la shebang gore anna ba khusyuk kana batho ba ba tseno setšhabeng a re eya kwa etsala gore o be jwale bane lona le tshwere AK47 le hape a ona tokomane e bontshang gore lona le tokelo ya ho tshwara le hape ala rupellwa go tla le na sekimiswa go tshwara sethunya se tshwanang sa mofuta o empa dile a tswela pele a tshwara sethunya seo a sona sekolo sa bana ba banyane le hape wa hlalosa gore khusyuk wa ntlha ke motho ya tsebahalang setšhabeng sena le apana bona batho ba merekora ka founu empa seo a sa mo thibella gore a tswele pele ka boitshwaro ba hae o le a tswela pele sa botlhoko gore batho ba mo tseba le hape ba merekora le hape wa hlalosa gore mefuta ya diwepo tse ne di tshwere a ngwa le sethunya di-weapons tse di sebediswang haholo ke masole le ntwe ha se di-weapons tse tlwaelehileng. Ba tswela pele a hlalosa hore morago ga gore le tshwarwe moqosuwa o mongwe wa lona o ile wa hlalosa e fane ka address la fa maponeseng le hape lona kaofela lona le bararo a fana ka address la hlalosa gore la lefelo le le siko Albamari empa le maponesa a na tsamaya a lo shebisisa address eo le netefatsa gore ke nnete ba le ba fumana gore address eo ha e eo go tsamaya lefelo le a leyo le hape ba le ba netefatsa ke ma-security badisi ba lefelo leo empa ba tswela pele ba batlisisa ba senya nako ba senya tšhelete ya mmuso o batlana le lefelo le seo le hape ba netefatsa gore ga o tsamaisela metsamaiso ya toka gore baqosuwa ba lokolle gobane lona ga la fana ka address ya nnete seo se tlhalosa gore ga ona motho ya tseba gore dula kae le aparela bonnete ba gore le ka sebaleng fa le ka lekolla le hape fa a shebisisa moqosuwa wa ntlha o na le makgetlo a robong a ntse a tlamela kgotleng le hape o fane ka diaterese tse robong tse sa tshwaneng se tlhalosa gore nna o ntshitse a le motho o senang nnete gobane fane ka diaterese tse fapaneng tse robong le hape go tlhalosa gore moqosuwa o mo mongwe ena wa lona ila magareng a lona wa bobedi la fana ka aterese ke ya go malwetse le hape ba ile ba ya maponisa di baagisane ba netefatsa gore ka nnete motho ona o teng ditafane empa o dula a le molosi yape wa tlhalosa gore motho ga a dula a le molosi o bonolo gore a sa fumaneng kgotsa a nyamalle a sa tlhaile pela tsotlha fa ba ka molekolla le hape wa tlhalosa gore ka botlalo le dintlha tse kaofela di go tlalisa gore bona re na bonnete ba gore dula kae le hape ba tlhalosa gore mabapi a bokgoni ba moqosuwa wa ntlha kgotsa madi kgotsa tšhelete e a nang le yona o ka etsala gore a sa tlotlela pela leoka fa ba ka molekolla ka beili le hape wa tswela pele a ba tlhalosa gore moqosuwa wa boraro e le mora wa moqosuwa wa ntlha a na tseba gore ile wa ntshiwa lekwalo kgotsa melawana e leng ya bewa ke lekgotla e ne tlhalosa gore bana ba hae kgotsa dileolo tsa bokgolo tse leng bana ba dulang lena ba tshwanetse ba dule le bokgoni mmogo fitlhela moqosuwa wa boraro a ba fetse go seka leolo empa moqosuwa na se tseba seo a ka se fela tseo a tswela pele a lo nka bana ka go sebedisa maatla a sa fumana tokello ya bokgoni e leng ena o ile a fiwa tokello ya gore a dule le bana go fitlhela moqosuwa wa boraro a ba fetse go seka leolo a ba tlhalosa a tswela pele gore lona ke gale le fana ka information e seng ya nnete mabapi a di-address tseo di batla ke lekgotla go netefatsa gore ba tla le fumana empa mabapi a go lona di fane ka address e seng tsa nnete sena se le bontsha le le batho ba senang nnete le gape o ka etsala gore le ba le sa gotla la molao fa ba fetsa go lekolla wa tlhalosa gore le gape o ka se le kgotso mo setšhabeng gobane wa iponagatsa gore kereke ya moqosuwa wa ntlha ile ya beswa ya phediswa ka mollo e bontsha gore o ka se le kgotso mo setšhabeng fa baqosuwa kgotsa moqosuwa wa ntlha a ka lekolla ba tswela pele go na le footage e leng ya bontsha lona fane ka lekolla e le bararo ba le tlhobane le gape ba tseba bapaki ka etsala gore ba thusitse ka dintlha tseo tsotlhe kaofela le mo o bona tsamaiso ya toka e sa duleng tekolo ya lona o bona le botoka wa le dile ditšhakaneng fitlhela le be le fetsa o seka molatong letlalo wa tseba
Thank you. Yes, what did you mean?
Sorry, Yusuf, there's a point, a vital point I should which I missed.
I'll allow you.
Your Worship, as indicated that in the affidavit, the kids, Your Worship, the two kids in this issue are pertinent to the case. Your Worship. The state still doesn't know where they are. No one from the state side knows where those kids are, and the state feels that to release accused persons out on bail after surmountable evidence which is indicating that it's kidnapping, in the state's view, back to those children, which would not be in the best interest of the children.
Yes, Mr. Poyana.
Thank you, Worship. I do not intend wasting...
Mr. Dlamini, wait. He needs to interpret that last aspect by Mr. Vilakazi. Did you listen to? Were you listening?
Yes.
Just interpret the last aspect made by Mr. Thank you.
Thank you, Worship. I did not want to waste your time, but the last point raised by my brother needs me to refer the court to section 21 of the Children's Act 38 of 2005. Just read it, Your Worship. The heading is Parental Responsibility and Right of Unmarried Fathers. That's the heading. 21, in bracket 1, the biological father of a child who does not have parental responsibilities and right in respect of the child in terms of section 20. And it makes it nice. Section 20 gives specific fathers a parental right. Section 21 specifically addresses the parental responsibility and rights of unmarried fathers. Emphasis there. Acquires full parental responsibilities and right in respect of the child. Full parental responsibility and right in respect of the child. There are subsections. Subsection A, if at any time of the child's birth he is living with the mother in a permanent life partnership. The state has already confirmed, Your Worship, that they were staying together and that right exists. B, if he, regardless of whether he has lived or is living with the mother, consents to be identified successfully applies in terms of section 26 to be identified as the child's father or pay damages in terms of customary law. Your Worship, those issues will be tested in a correct platform. But the first point it has given, the third applicant, undisturbed full parental responsibilities and right in respect of his children. That is law of this country. What disturbed me, Your Worship, my brother here did not argue, he was testifying. He testified that there is a interim court order, but that interim court order is not mentioned in the police affidavit, is not mentioned, is not even brought to court, just a hearsay. Most of his submissions, Your Worship, it was just him testifying. The children has not been denied that they are with his father. And that's the reason why the interest of the children is that their father must be released in prison. The allegation of kidnapping has no basis. Here is the law telling you any other person that wants to remove this right must approach the court, and the court must grant that right. And they have to satisfy the court why these children should be removed from their father. That's the position of worship. That's a legal situation. And unfortunately, my brother did not address it. That's the position of this country, right of children. We are proud to say that for the first time after the constitutional democracy, children's rights were taken into care, and the Constitution has put in a right to that. Your Worship, the Children's Act was enacted to fulfill the section of the Constitution. I've already submitted earlier, Your Worship, that neither the police nor any other person can change that law. Only the court has the power to remove children from their father and give it to any other person who can look after the interest of the children. That is the position, Your Worship. Some of the issues raised, I won't never even try to go to them. My brother here raised issues that are not in the statement of the policeman. And in short, he was just giving a hearsay testimony. There is nothing that has been placed before court that it definitely will necessitate this court not to grant bail. Nothing. It seems as if prosecution rely on the so-called withdrawn charges, different addresses. Your Worship, what is important in what prosecution is saying there. It does not say that in those 9 withdrawn charges, the first applicant or the first accused failed to attend court sitting. Nothing. In those 9 charges, there is nothing says that the first accused was a threat to community. May I just look at my beautiful, nice pocket book and address each and every point that my brother tried to address. In the 9 alleged withdrawn cases, potent signal that there is nothing saying that they were withdrawn because the accused has failed to attend court, that the accused endanger the safety of the public or commit Schedule 1. For B, where there is likelihood that the accused is or she, where released on bail, will attempt to evade his or her trial. There is nothing. It does not help the prosecution because whatever they say, the accused or the first applicant attended until they withdraw those charges. It's not in his liking or made for the charges to be withdrawn, except if the police try to say some of their people are not doing their work. If they are not doing their work, it's not the problem of the accused. See, where there is likelihood that the accused, if he or she were released on bail, will attempt to influence or intimidate witnesses. Nothing that is said on those 9 alleged withdrawn cases. In fact, those work in favor of the accused because there is nothing that says he did not or comply with the requirement of section 64 in bracket A to E in bracket. D, where there is likelihood that the accused, if or she were released on bail, will undermine or jeopardize the objective of proper functioning of criminal justice system, including bail system. There is nothing in those 9 alleged withdrawn cases that the accused failed to comply with bail orders. Nothing. E, and I like E the way it's captured, where in exceptional circumstances, there is likelihood that the release of the accused will disturb the public order or undermine the public peace or security. Nothing. In all those alleged 9 withdrawn cases, there's nothing that says he did this. Your Worship, I have already submitted that the state did not contest what the the accused or the applicant has put before court. And the only contestation is this document. Nothing that is not here could be pushed to this court. You're putting it back door. The issue of interim court order, they try to smuggle it in back door. There's nothing. They will have talked about it in their police statement. They tell us about the videos, Your Worship, and they selectively talk about specific videos that they talk about. There are many videos circulating talking about the incident, even the burning of the church. There are many. They don't talk about it. And who actually was there? There are videos showing who was there. It's circulating, it's public knowledge. And in this case, they talk about a weapon that they have not even brought to court to say that we have this particular type of weapon. They rely on what is the video. Your Worship, any video is subject to be what is the pronunciation? Authenticated in order to be admitted in court. We cannot just rely on something that somebody is talking about without knowing where it comes from, who took it, how, or was it doctored or not. That's the position, Your Worship. Videos, hearsay, all what they were putting before you, Your Worship, is just a hearsay. We have handed over a municipal statement proving residential of the first applicant. They keep on running, talking about a different address in different things. Your Worship, what is important is that do we have a fixed address for the applicants? If yes, Your Worship, they complied with that requirement. And there is proof of it. Unfortunately, the desperation result in desperation action. What the prosecution was trying to do was an act of desperation to try to nullify what is obvious. What is obvious is that the third applicant is the biological father and the law grant him the rights. If they can give me any other rights, then I will understand. But as for now, before this court, there's only one issue. It is the Children's Act that gives this court guidance. I have, Your Worship, given you case law. And my brother mentioned Dlamini. I like it. I like that case. It actually favors the applicant. That is the importance of that. There is no case law that will go against a simple, straightforward situation of a bail. A bail is a right, it's a constitutional right, until where the court is satisfied that there is a danger. Without that, we have satisfied the requirement of bail, and the court, if it likes, it could set conditions. Those conditions are there to mitigate about what the state fears. Those are the conditions. It's clear. The case line I've given, it talks about it. To say when the issue of a bail is an important constitutional issue, not just a right, it's a constitutional issue that must be protected at any way. That right, the court is required to protect that right. It is the duty of the court not to keep people in prison unnecessary because satisfying some egos or some people who want to settle scores. This is the position, Your Worship, that there is a point. I have already alluded that the children are not going to school. We have never denied that we don't know the whereabouts of the children. They can't go to school because its father or their father is behind bars. And their rights are affected. We have said common cause with the state that those children are not well. There's no dispute about that. And as long as the father is behind bars, the life of those children are at risk. I once, some years ago, Your Worship, I was a trade unionist. The mother of the child was detained in Tembisa, and when I took care of the child, and the police wanted me to hand over that child, I said, prison is not for children. I cannot take a child to prison. Prison is for the criminals. And the whole world agreed with me. The mother was released to look after her child. There are certain things that you cannot compromise. You cannot compromise because the police want the children, because they are police. When the law is clear, who must take care of the children? Your Worship, I have said enough. I do not want to waste your time. Oh, I'm reminded of this issue of AK-47. Your Worship, that falls in the trial. That is an issue of the trial that will deal whether there is such a thing or not. It's an issue that has been brought up as if people have never been released on bail, having been involved in Schedule 6. Have been released, Your Worship, not 5, 6. Worst situation. When they satisfy the requirement of Section 64 in bracket A to E. Now, all this allegation, Your Worship, is to try and create a situation where the court will be confused in coming with a correct decision. Unfortunately, that's not the case. The court first is the guardian of the minor children. So the court will have to take interest of the minor children. Secondly, the court is the protector of our Constitution. Our Constitution regards the accused as innocent, no matter how strong the case or weak the case. The court should look at the interest, balance the interest of law and the interest of the accused. The court should avoid playing into the gallery, public gallery, where because it's Pastor so-and-so must be kept in prison denying him all his constitutional rights. We died for these constitutional rights. We fought for them. We cannot compromise them, because those are the rights that come from the blood of our people. It doesn't matter whether it's Pastor Mboro, the constitutional rights must be respected. Can I approach your worship?
Yes, you may.
That concludes my submission.
Thank you, Kitlamina.
Muso ba ile ba netefatsa ka nnete ile wa bana ba ditatoleho bana se se bontshang gore wa bana le le mokhusuwa ba bana ona le tsone ditokelo tsa a dile bana a ba komele le hape a ba bua mabapi le dintlha tse di le ba bua ke mosebisi gore o la bua ka interim order la wana mo tswana le wana tsiwa ke le khotla na se makatsang ko se asa kwala ko Africa meeting ene ya se ko se na di tlhatse ba di ne ke sa rona ko Africa meeting ko le palo la bukane le sha na isa le hape ba kasi mo tswa resi ko tswa bo la na ba no ki ta na ko ba le la wa ke ona mo tsule ko lo le ka o le a sha ko na ko ba ke na kanti wa ba na ha na wa sha le sa ko le khotla ke lona sola le na le pa offer motho go tswa mo la matla ya mo ke la ditokelo tse ke bona go tlhafela le nna ya ba tsela pele a tlhalosa mabapi a ditlhalo le patlo district mosebisi wa tlhalosa gore mosebisi o tshepetse a o le mabapi a melato e re mo e le ya khala ya mo khosuwa wa ntlha empa ka mo malibadi mo melato e re mo e khabile a ona sepe se ile sa bontsha gore khosuwa wa ntlha o le a leka go maria a sa gale go tlotla ya ona sepe se se bontsha gore khosuwa wa ntlha o le a ba motho go se setšhabe kgotsa fa le ba fetsa go mo lekolla ya tsona e etsa e nngwe fa ba fetsa go lekolla le hape a ona bopaki bo mosebisi a bo tlisitse go bontsha gore khosuwa wa ntlha ko melatong e re go e le a tloswa lengwa na kwa sa tsene a tlhatlhela le go tla ile a ba motho a sa lefelele na ngwana kgotsa motho o leng a tshosetsang baki le hape wa tlhalosa gore dintlha tse di ngata tse mosebisi a diile ga di a kwala mo afidaviti ke bopaki ba wa qala go iqabela la go tlhaka jeno jaaka melawanile wa tshwa a motsotswana e le interim order kgotsa video e le ba e tletse le hape wa tlhalosa gore ba tshepetse mo bopaki mo bongata mo ba bo boneng ko video empa ga ona motho o le wa netefatsa nnete ba video eo ka mo he yona o bona go tlhalisa a jaaka bopaki ona monnete ka gore ke a bonnete video e ba bua ka yona empa bona ka mo tlhakoreng la bona ba hisitse lengwalo la masepala go netefatsa kana ya address o bontsha mo le ka fumane ya ke fa ba fa le ka lokolo ke ka go na a sa tlhalohanye baneng tse le bua ka ditaba tsa gale mo le mokhosuwa a na fana ka diaterese tse ya ka tsebo ya lona a ba tswela pele a bua mabapi a ditokelo tsa bana a ba tlhalosa gore mo kgethollong ditokelo tsa bana kgotsa go latelong ditokelo tsa bana a gore ntate wa bona a dile ditšhakaneng ya ke lona lebaka le etsang gore bana ba sa kgone thuto a go ba ya sekolong ke gore mosebeletsi wa bona kgotsa ntate wa bona o ntse a kwaletse ditšhakaneng ke ga o le jalo mo kgetholla ditokolong tsa bana ke mo ditokolong tsa mokgosuwa wa boraro Wapunya tabaya situnya sa 1847 haba kaukena na wanyona ante tabwa kayona asiba katule useka mnatokona na kuka asibiwa kwa asibu tusoka na usekwa ya hape ukupa bakotalishe bisiseli tokelo tsabana bana hanele bana ke eng se tla sebetsa bana fa tsela go pele wa hlalosa go ka dintlha tsotlhe tsa dikisitseng le bopaki o bontshitse ka bopaki bo go bo feletseng go tsamaiso ya toka imela tokolo ya pele bona le bona go bona le tsona ka motho na pele fikela le fetsa se se wa ke mo
Mr. Ponyana, I'm going to read, then you, when I pause, you. I'm saying I'm going to read, and then I'll pause, then you interpret.
Okay, we're doing it.
Okay. All right, then the court is about to deliver judgment in this matter. It's case number DC 2/2022/2024 in the matter between Paseka France Botswaneng, the first applicant, the second applicant being Vincent Kemelat Baloy, the third applicant being Revival Motswaneng. This is the state. There is a bail application brought by the applicant before this court. It is imperative to note that this bail application was on the roll of District Court number 2 next door, and due to last-minute logistical and heavy court roll of District Court number 2, the matter was placed before this court. The application commenced at about 2 p.m. on Friday, the 16th of August 2024, and the court noted the displeasure of the defense that the state was deliberately delaying the said matter. Mr. Vilakazi is appearing on behalf of the state, and the counsel for the three applicants is Advocate Lamini. The state is opposing the bail, and that it is a Schedule 5 bail application. It is common cause that the applicants before this court are charged with 12 counts of various offendings ranging from kidnapping of minors, 2 counts of assault by threat, 1 count of assault, possession of prohibited firearm, 3 counts of discharging of a firearm in a built-up area or any public place, 2 counts of pointing of anything likely to lead a person to believe it is a firearm, 1 count of malicious injury to property, and 1 count of possession of dangerous weapon. The various offences were allegedly committed on the 5th of August 2024 within the court's jurisdiction. Now, it is tried law that the applicants are entitled to be released on bail if the court is satisfied that the interests of justice permit their release as envisaged in Section 60, Subsection 11B of the Criminal Procedure Act. This section informs us that the court shall detain the accused until they are dealt with according to the law unless the accused adduces evidence which satisfies the court that the interests of justice permit their release. The applicants submitted the affidavits in support of their bail application. In the affidavit, they detail their personal circumstances and confirm that they intend to plead not guilty to the charges. The applicants' affidavit were confirmed and signed by them, and they were handed in and marked Exhibit A, B, and C, respectively. Applicant's number one's personal circumstances was read onto the record. He states that he is a pastor at Incredible Happenings as well as director of Incredible Happenings Trading CC. He does not have any previous convictions and or any pending cases or any domestic violence order or harassment orders against him. He stipulates that he is deeply rooted in the Katlehong region and he has children. One of the children of the accused number one is accused number 3 in this matter. He further in his affidavit states that he has employed 30 people from whom depend on him for their living. As a result of his continued detention in custody, he will severely prejudice the said employees. Further to that, he informs the court that he financially contributes to the upkeep of his grandchildren, as the church which he is a pastor of has employed applicant number 3, and as a result of his detention, the best interest of the children will be affected. He can afford bail of 3,000 rands. Applicant's 2 personal circumstances were also read onto the record. He is the bodyguard of the first applicant. He has no previous convictions, has no pending cases. He has no domestic violence orders, protection orders against him, no harassment orders against him. He states that if he fails to provide services to applicant number 1 as a result of his detention, his employment will be terminated. He can afford bail of 500 rands. Applicant's 3 personal circumstances was also read into the record. What the court can gather from this affidavit is that he is the father of the 2 minor children who are referred to in count 1 of the kidnapping charge. He has no previous convictions, no pending cases. He has no domestic violence order, protection orders against him, or harassment orders against him. He submits to the court that his 3 minor children need him as they depend on him. He informs the court that he is a widower and his continued detention will not be in the best interest of the minor children. He can afford 500 rand bail.
dintlha tsohle le bopaki bo lebisitsweng wa bonahala moqosi wa boraro ke yena ntate wa bana mabaping a molato wa ho kidnapa le hape wa hlalosa hore le yena a na katlelo tsa kgale a na lelatong le hana harassment order a na protection order le gape o fetsa wa hlokafalla ke mme wa bana ditjhelete ka kgonang ho ipatala ke ka fana ke fa le kgotla le ka pele le hape wa hlalosa hore fa ka tsona le ditjhelete le ka bona kgethollo kgotsa ka sebeletse bana.
In all their affidavits, they stated that they addressed all the provisions and or factors that are listed under Section 60, Subsection 4 to 9 of the Criminal Procedure Act. That was the applicant's case, and they closed their case. Now, the respondent provided a long bail application affidavit. It was deposed by the investigating officer. It was read onto the record. I will not repeat same, but only provide a brief summary of the day of the incident. The captain states that in addition to the above mentioned offenses, there is also a charge of trespassing and contravening Section 21A of the Private Security Industry Regulation Act 56 of 2001. According to the investigating officer's affidavit, there seemed to be an incident that transpired on the 1st of August 2024 before the main incident being the 5th of August 2024. The investigating officer submits as follows from paragraphs 8 to 9 of the said affidavit that there were accused number 3 had taken 3 minor children from the school without informing anyone, and this necessitated assistance of the police, who attended to the property of accused number 3 and 1 and then the property of accused number 1, which they were not found. Now, on the 5th of August 2024, one of the witnesses who is employed at the school where the minor children of accused number 3 attend and where the said alleged offences transpired, found the said minor children in their respective classes. The said minor children informed the witness that their father, accused number 3, accompanied them to school. When school times had concluded, accused number 3 went to collect his children, and this is when the scuffle and chaos erupted at the said school. It is stated in the affidavit that the deputy principal attempted to contain and resolve the said impasse, but was unsuccessful, and an unpleasant scene therefore erupted and or started. The witness observed that accused number 1 had 2 pangas, or machetes if you can say, which he used to intimidate and threaten individuals who were on the scene. Accused number 3 was pleading with the deputy principal to release his children into his care. It was at this point, as the witness describes, that accused number 1 gave accused number 3 one of the pangas, and he forcefully opened the burglar gate and removed his children and left the school premises. Accused number 2 is described as the individual who was carrying a firearm described as a rifle.
mopaki o mongwe ila bona moqosuwa wa ntlha ona tshwere ditaba tse pedi a tshosetsa bapaki ba ne ba le mo ketsahalong eo le hape moqosuwa wa boraro yena a ntse a kopa principal wa sekolo go kopa ba le bana ba tsamaye le yena ke moo he principal a dumela ke moo he moqosuwa wa ntlha a ka qetela go a ikepanga a e fela moqosuwa wa boraro gore a leke go bula heke ya sekolo ba sebedisa matla go a kgone fumana bana le hape ile wa bana le badula tlhalosa gore ila bona moqosuwa wa bobedi yena a tshwere sethunya mo ketsahalong.
The investigating officer submitted that a witness was pointed with a firearm described as a pistol by accused number 1 as they were exiting the school premises. This was when it was observed that accused number 1 was instructing one of the witnesses not to record the said incident. They entered into the vehicle of accused number 1 and drove away. The witness also states that they heard gunshots before all 3 accused drove off. The investigating officer states that the maternal grandmother of the 2 minor children did arrive at the school premises upon her other daughter, who went to collect the minor children, informed her that accused 3 had taken the children forcefully. She's one of the witnesses who claimed that she was assaulted by accused number 1. The investigating officer further stated that after the first court appearance, which was the 6th of August, he went to view the video footage where he observed the said vehicle of accused number 1 and him discharging a firearm in public, and the said firearm is not the same as the same firearm that was in the possession of accused number 2 when the incident happened. Paragraph 10 of the investigating officer's affidavit is key-worthy to note that it offers explanations of the accused's physical addresses, which will be expanded upon below. The investigating officers then individually provided information about the respective applicants before court. This is their personal circumstances, their criminal history, etc. And applicant number 1, the investigating officer is opposing bail on the basis that the applicant's residential address is negative and that there's no number 2027 Gumete Street in Albemarle. Therefore, accused number 1 offered an incorrect address, which will thus be impossible to trace. The other view that the investigating officer holds is that the accused number 1 is concealing other firearms that have not been recovered by the police, and as such, this poses a danger to the witnesses and the community. The investigating officer states that accused number 1 does not have any previous conviction or pending cases. However, in his profile, he has 9 cases that were withdrawn. He tells the court that accused number 1 was the instigator of this incident and is a danger to society, more so to the witnesses and the maternal grandparents. He further opposes bail in that this incident was widely publicized on all social media platforms and has shocked the community. He further submits that the accused are in danger as accused number 1 is a prominent pastor, and subsequently of this incident, his church was set on fire and burned down as a result of the community being angry and unimpressed with the conduct of accused number 1. Applicant number 2, the investigating officer is opposing bail because his address has been verified and he resides alone in Boksburg and he can evade his trial. He further submits that he's a danger to society as he does not possess any licenses for the firearm he had in his possession and that he can easily access unlicensed firearms. Applicant number 3, the investigating officer is opposing his bail in that he provided incorrect address, therefore he has no fixed address. That was the respondent case and no further evidence was presented. The investigating officer's affidavit was handed in and marked Exhibit E. Now, in deciding whether applicants are candidates to be admitted to bail, the court needs to clarify certain issues. Whether the applicant has discharged the owners under Section 60, subsection 11B of the Criminal Procedure Act. Another aspect is that the court has to consider is whether the applicant successfully passes the factors listed under Section 60, subsection 4A to E, as well as Section 65 to 9 of the Criminal Procedure Act. Now, the court would like to make it clear that it is not the duty of this court to determine the guilt of the applicants before this court. That's for the trial court to determine. What is of importance is that it's for the court to weigh up the evidence before it and provide a value judgment whether on a balance of probabilities have the applicant before this court successfully discharged the required onus placed on them.
ana lona jaaka batlosiwa le se le fane ka bopaki mo go tsofetsang gore go tla le ka qeto le ka bonang gore tsamaiso ya toka e dumela kgotsa e kgatlhanong le tekolo ya lona ka pele.
Now, the right of an accused to apply for bail, it is found in our Constitution, Section 12 and Section 35 for 1, D, E, F. They expressly protect this right to apply for bail. In the case of S versus Japan, it states that the right of an applicant to apply for bail and the urgency thereof is important, but equally important are the rights of the public and the complainant as well.
S versus Japan, which is
the court has to look at the factors listed in subsection 60, subsection 4A to E of the Criminal Procedure Act, but not in isolation, as these factors must also be read in conjunction with section 60, subsection 5 to 9. These are factors to determine whether indeed the applicants are or do qualify to be admitted to bail. The court is also mindful that an accused person cannot be kept in detention pending his trial as a form of anticipatory punishment. The presumption of the law is that he is innocent until his guilt has been established in court. The court will therefore ordinarily grant bail to an accused person unless this is likely to prejudice the ends of justice. The court will quote, I see Mr. Dlamini quoted it from S versus Diale. The court will quote the same quote from S versus Swanepoel, which says that a court cannot find that the refusal of bail is in the interest of justice merely if there is a risk of or possibility that one or more of the consequences mentioned in subsection 4 will result. The court cannot grope into the dark and speculate. A finding on the probabilities must be made unless it can be found that one or more of the consequences will probably occur. I turn now to look at the facts presented. The applicant before this court submitted affidavits in support of the release on bail. The court must disappointingly note that all three affidavits was a cut and paste of one of the other with only varying differences, as the respective personal circumstances can never be the same. I must also note that the said affidavits were littered with unnecessary spelling errors. There was not much great care and skill taken when the said affidavits were drafted. Case in point, the said surnames of applicant 1 and 3 are different to that of the surnames on the chart sheet. Now, there is a clear copy and paste of the criminal procedure sections, which the applicants must elaborate and discuss in order to show that they are candidates suitable for the release on bail, but they fail to do so. The investigating officer gave a detailed and comprehensive bail affidavit. In the affidavit, the court was given a clear picture of what transpired on the day of the incident. It is also tried law that hearsay evidence is admissible in bail proceedings, and that bail process is sui generis in nature. Basically, anything goes in a bail application because of its uniqueness. Now the court has to weigh up all the factors and decide on a balance of probabilities to determine whether applicants can be admitted to bail. The case of S versus Shititak encapsulates this reasoning clearly, which basically states that bail proceedings are sui generis in nature. The state does not oblige in its turn to produce evidence in its true sense. It is not bound by the same formality. The court may take into account whatever information is placed before it in order to form what is essentially an opinion or value judgment of what an uncertain future holds. It must be prognostic to do this. It must necessarily have regard to whatever is put by the state in order to decide whether the accused has discharged the onus placed on them. Now let's look at applicant's number 1, affidavit. It is common cause that he is a prominent pastor and his church is very well known. It was also not disputed that the said incident was publicized on national television and on social media. Applicant number 1 simply gives the court nothing other than to place his circumstances on record. He does not thoroughly explain the impact of his incarceration. He only informs the court that he is responsible for 30 employees and that his church members will suffer spiritually if he is not released. He does tell this court that his mother will suffer as he financially provides for her needs and medical needs. He does not explain how he was arrested, nor explain the charges that he faces. I touch on the manner of how he was arrested because the investigating officer in his affidavit submits that the J50 warrant was executed in order to arrest applicant number 1. It is common knowledge that a J50 warrant is applied for when a suspect is wanted and cannot be located at their respective residential address. This, the court believes, is also one of the important aspects that applicant number 1 should have thoroughly ventilated in his affidavit.
J50 wa re teng le kwalo le tla le khotleng le tsisa maponesa gore mothusiwa o tshwanetse a hlahlele bane ena a fumane address e re ntselang go yona.
He does not explain that this incident was recorded and therefore causing a social media frenzy. He does not explain that on the day of his bail application having commenced, which was the 16th of August 2024, his church was burned down to ashes, as the investigating officer informed the court. Applicant number 1 simply gives no effort in addressing the factors which would enable him to successfully discharge the onus placed on him. The court disagrees with the investigating officer that applicants 1 and 3 do not have fixed addresses. It is unbelievable that an individual of the stature of being applicant number 1 that he possesses will not have a fixed address. It is clear that the address on the said charge sheet was incorrectly spelled. Applicant number 1 and 3 provided an address by submitting a rates and taxes account from the municipality, which was handed in and marked Exhibit D. I do agree with Mr. Vilagazi when he says that the 2 addresses were combined, because 2072 Gumeta Street is in Katlehong, and then the address that's provided by the applicants before this court, the one in Geffen Avenue, is in Albemarle. So it's clear that the said address was combined. Therefore, that's why the investigating officer could not locate it in Albemarle. Furthermore, it is the submission of the investigating officers that the police officers, they went to applicant's number 1 residential address on the 1st of August, 4 days preceding the main incident. So that surely confirms that the address is indeed positive and was verified. Mr. Vilagazi made submission that the previous cases of applicant number 1, he gave different addresses. This cannot be a basis to state that he does not have a fixed address. Even for applicant number 2, the investigating officer cannot come and tell this court that just because applicant number 2 resides alone, he is a flight risk and can evade his charge. His address has been verified, therefore the court holds no issue with the addresses of applicants number 1, 2, and 3. Applicant number 2's affidavit also provide this court with nothing. Personal circumstances are on record, and that is as far as the affidavit goes. He neglects to fully canvass the provisions that are of importance in determining whether a candidate is suitable to be admitted to bail under Schedule 5 offense. Applicant number 2 fails to address the issue of him being a good bodyguard and whether he is registered by the applicable authorities to become one. He does not dispute that he holds no firearm license, and he does not dispute that he was on the scene of the incident. All he gives to the court is that he intends to plead not guilty. The investigating officer also submits that applicant number 2 was brandishing a firearm which was described by the witnesses as a rifle. The court cannot ignore this point. I now turn to applicant number 3. Now, inasmuch as applicant number 3 gave a sloppy affidavit which does not tell this court much, case in point, he says he is a widower but does not provide proof to this effect. The investigating officer's affidavit comes to his aid and assists applicant number 3. The investigating officer gives a background of why the said incident transpired. The investigating officer also does not mention much apart from him opposing bail against applicant number 3 in that his address is negative. I have concluded above that the court takes no issue with the addresses that they have been verified. Now, Advocate Lamini, counsel for applicant number 3, correctly points out that applicant number 3 does have parental rights and responsibilities as protected in Section 21 of the Children's Act. There is no court order before this court that states otherwise. The 2 minor children have only one parent, and that is applicant number 3. To deny the applicant number 3's right to take care of his minor children will be an injustice to the, and this court will not go down that route. Now the investigating officer provides a picture to the court of what exactly happened on the day of the incident. What is also worth noting is that the investigating officer suggests that it will be beneficial for the accused to be kept in custody as a measure to protect the applicants before this court. The affidavit is clear that there is an outcry and displeasure of the accused's conduct. To have a prominent pastor commit such a heinous act in the presence of minors, which he ought to have protected as he is their grandfather, has left the community angered. So much so, as the investigating officer stated, in that the church The applicant's number one's church has been burned to ashes. This is indicative of the anger of the community. Perhaps they could as well be paying for his blood. The affidavit of the investigating officer also shows that there are too many witnesses who were subjected to this ordeal, and what could also not lose sight of the fact that this incident occurred in a public school where minor children are enrolled at such school. The conduct of the applicant may as well have left the witnesses and learners traumatized. Now, Section 28, subsection 2 of the Constitution tells us that the fundamental point that the best interests of the child are of paramount importance, and as such, it is the duty of this court to protect children and ensure that they are protected in the environment where they receive education. This is not only in respect of the two minor children affected by this incident, but by the learners of the said school where this incident transpired. To be brandishing dangerous weapons and firearms in an environment and institute of learning, this the court shuns the behavior of such. Now, in the case of S. vs. Shabalala, it was stated that the court must assess the appellant's future conduct in the light of existing or historical facts and circumstances. I cite this case in support of the factors listed in section 60, subsection 4A to E of the Criminal Procedure Act. The court then must balance the right of the accused and those affected by the incident. Did the applicant discharge the onus placed on them? Do they satisfy this court with the evidence that they have placed before this court with the affidavit that they are suitable candidates for bail? Now, the only thing that this court must do is just to make sure that it's satisfied that all three applicants before this court, they can attend their bail, their case before this court. This is not the duty of this court to determine the guilt of the accused, as I've said. That's for the trial court to do. Now, it is quite unfortunate that the affidavits presented by the applicants before this court were not satisfactory, and simply they were just not giving giving of anything. The onus rests on them to demonstrate that they've adduced evidence that which are in the interest of justice to permit their release. The court has considered all angles and dissected the affidavits, and simply there is no indication that the said onus was discharged. This court is a creature of statute, and it does not operate on emotions or influence. It is not a reactionary court, but simply deals with the facts presented before it. It is a creature of statutes and does not have inherent jurisdiction as that of the higher courts. So it simply can only do what is permitted to do within its own legislative framework. If the applicant fails to discharge the onus placed on them, then it is therefore clear then what should follow as a result thereof. The applicants did not have an obstacle of discharging the higher burden found in Schedule 6 bail applications. They simply needed to demonstrate to this court that the interest of justice permits their release, as opposed to the higher test found under Schedule 6 bail application. Their affidavits do not dispute that they are linked to the offenses preferred by the state. There is a strong case against them, and frankly, they did not put up a fight in assuring that the evidence submitted by them hold enough water to discharge their owners. Now, I have expressed above that the investigating officer comes to the aid of applicant number 3. It is clear that the investigating officer has no reason why he is opposing the release of applicant number 3, and in the circumstances, the court must do what is fair and just. Applicant number 1, 2, and 3, please stand. Now, the court ultimately looks at what is presented before it, and it provides a valid judgment from the said evidence. This court is persuaded that this case consists of so many probative factors which tips the scale in the respondent's favor. Now, in considering all the evidence before this court, the evaluation of the factors listed in Section 60, subsection 4 and 5 to 9 of the Criminal Procedure Act, applicant 1 and 2 have not discharged the onus that rests on them and have not adduced any evidence which has satisfied this court that it is in the interest of justice that they be admitted to bail. Applicant number 3, there is no basis that he should be detained up until the finalization of this matter, and therefore the court shall grant his release from custody.
e dumela jwang kopelo ya bona ya pele ke ka hoo le he ka le dumela kopelo ya bona empa Joshua wa boraro ke la Joshua wa boraro Maponesa kgotsa maponesa a fana ka mabaka a hlalosang baneng ba le kgatlana le kopelo ya hao ya pele ke ka hoo he kopelo ya hao ya pele se ya dumela empa wena Joshua wa ntlha wa bobedi ha fana ka mabaka a kgotsofatsang hore ka lekana ka pele kgotsa a bontshang gore tsamaiso ya toka e dumela jang tekong ya ka metsi ao maposo wa ntlha wa bobedi wa hanetswa kopelo ka pele wa boraro ya dumela.
So then the order is as follows. Applicant number 3, you are released on warning with the following conditions. You are to have no direct or indirect contact with the witnesses of this matter, save for the maternal grandmother and aunt under the guidance and assistance of the Children's Court. You are prohibited from entering the said school premises where this incident occurred up until the finalization of this matter. The court is aware that this condition, it will impede you exercising your parental rights and responsibilities, but this is only until the finalization of the matter, alternatively the outcome of the Children's Court matter. You are therefore warned to appear at the Knox Court date, and failure to do so, you may have your release on warning cancelled. And therefore applicant number 1 and 2, your application for bail is hereby denied.
Children's Court, even some allow and Joshua wa ntlha wa bobedi o na tla tlhatlhelwa letla di chakane go fitlhela le benefits tsa go second batho tlhalo antse go
Mr. Vilakazi, date?
no
Date.
The court, or rather the state, is paying this court's indulgence, or should that maybe the state be granted a period of 2 months for the investigations, stop ballistics, outstanding, and so forth.
I don't know. Then the date with the defense then. It will be for investigations, correct?
Social.
The date, Advocate Dlamini?
Mr. Dlamini? 2 months.
That is too low. Your Worship, that's too low.
I don't know.
I understand, Your Worship. However, we're going to be in the same position, because if we get a shorter remand, we're going to ask for postponement again for further investigations in any event.
How many?
Your Worship, 2 months. Accused number 1 and 2 in prison. That's completely situation where they are denied.
But the state is saying that they still need to investigate. And I'm sure with ballistic report, we know the situation at our criminal laboratories, that there's a backlog there. So surely that ballistic report is going to take quite some time. Hopefully it will be sped up.
Can I consult?
You may.
Your Worship, we will accept the state proposal, but we need a date.
Yes, you must provide me the date. Look at your diary and let me know.
Is it too much?
Yeah, date. I'm here.
Give them a date.
Okay, indulgences. The 21st of October.
What day of the week is it?
Monday.
Is it suitable, Mr. Dlamini?
It's suitable.
Gentlemen, you then appear in District Court number 2. That's the reception court. On the 21st day of October for investigations. Accused number 1 and 2. Since your bail has been denied, you shall remain in custody. Accused number 3, you are released on warning with the condition that was set before this court. You are warned for 8:30 District Court number 2. If you don't come to court, a warrant of arrest will be authorized against you. 21 October, DC2, 8:30. I want to advise the gallery the court is still sitting with other matters, so if you're going to leave, please leave quietly. Yes, that's what I wanted to say. The court is still sitting. I've got other matters to proceed with. So if you're going to leave, please leave quietly. Are you off record? I don't know if they're still recording, so let's wait.